law-abiding Americans into felons by banning pistol braces.
But at the crux of this is a bureaucrat making a unilateral decision to try to turn millions of Americans into felons.
It's mounted to the rear of the pistol. It's designed to anchor the pistol to the shooter's arm.
It wasn't a fully automatic gun that was banned in 1986. It wasn't the bump stock.
The ATF claims that Judge O'Connor is disobeying the Supreme Court's recent emergency order, which is why they are now crying out to the Fifth Circuit and requesting them to overturn an injunction against their frames and receivers rule. Legal battle over ATF rule. The ATF has since complained to the First Circuit. Recently, the Vanderstock versus Garland frames and receivers cases caused the ATF to incur a significant loss. While this case is moving through the appellate process, Judge O'Connor, in a federal district court in Texas, granted a limited preliminary injunction in favor of two companies, Defense Distributed and then also 80% Arms.
Most significant federal gun restrictions in decades on Friday following years of false starts and failures to tighten gun laws.
That you said that all assault weapons should be banned. Is that a fair statement?
Certain bump stock devices, like the one used in Las Vegas, are illegal under current law.
However, the ATF is now asking the Fifth Circuit to strike down that injunction because they claim Judge O'Connor is disobeying the Supreme Court and their recent 54 emergent case rulings. The Fifth Circuit has also ordered that the ATF needs to answer two specific questions that have huge significance about this whole issue going forward and really could paint the ATF into a huge corner. In this case, the original plaintiffs, FBC and Tactical Machining, sought preliminary injunctions to halt the enforcement of the ATF's new rule while this case was making its way through the process of review. Originally, Judge O'Connor granted a limited preliminary injunction against the ATF, which prevented the ATF from enforcing the rule against Tactical Machining and then also their customers. Looking at the ATF's rule on frames and receivers, Judge O'Connor found that it is facially invalid under the plain text of the statute and that Congress did not grant the ATF authority to regulate these types of items. After that, other companies like Defense Distributed and then also 80% Arms sought to intervene in the case as new named plaintiffs.
Under the new rule, firearm owners will be required to obtain special registration, surrender or destroy their brace.
Percentage of the shootings were done by semi-automatic weapons or rifles. The number one weapon that they use, basic pistol.
Getting weapons, AR-15s, out of the hands of people who shouldn't have them.
They also asked the court to grant the same limited protections that were granted to Tactical Machining and also their customers. Ultimately, the court, Judge O'Connor, did extend the protections to all these new companies. Now, after the preliminary injunction stage, FBC and the plaintiffs sought to win the entire case by asking for a motion for summary judgment. In response, Judge O'Connor did grant a motion for summary judgment and he vacated the frames and receivers rule in its entirety. That was a nationwide vacatur, and it was a huge win because the judge struck down the entire rule as invalid and found that the ATF should not be able to enforce it at all. Of course, the ATF was not going to let the summary judgment sit and the nationwide vacatur sit, so they filed an appeal up to the Fifth Circuit. Then, the ATF sought a stay from the court on that whole vacatur of the frames and receivers rule. They asked the Fifth Circuit first, and the Fifth Circuit denied it. Then they decided to go up to the Supreme Court and seek emergency relief. They wanted an emergency stay of that nationwide vacatur. They did not want the rule to be vacated nationwide.
Partisans at the ATF have really run amok, infringing and trampling on the Second Amendment.
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
That's what gun control is all about. The ultimate goal is an unarmed and subjugated America.
That emergency application was submitted to Justice Alito, who then referred it to the full court. In a 5-4 decision, the Supreme Court agreed and stayed the enforcement of the summary judgment decision while the Fifth Circuit appeal was currently going on. The order of the Supreme Court stated that the application for stay presented to Justice Alito and by him referred to the court is granted. In that same order, it was indicated that Justice Thomas, Justice Alito, Justice Gorsuch, and then also Justice Kavanaugh would have denied that application for a stay. So, the indication from that is that Justice Roberts and then Justice Amy Coney Barrett joined the left to grant the ATF stay. But that order from the Supreme Court, that 5-4 order, stayed the summary judgment while the Fifth Circuit appeal is currently going on at the Fifth Circuit level. Legal battle intensifies. ATF's rule faces challenges. It was noted that the oral arguments for that summary judgment hearing have taken place before the First Circuit. All indications are that the First Circuit will actually rule in favor of the pro-2A side. It did not seem like they agreed at all with the ATF's arguments, and the ATF attorneys really had a hard time trying to justify this restriction. It just seemed like the First Circuit was not buying any of that.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
That men and women in this country have the right to defend their own lives.
After the Supreme Court issued a 5-4 emergency stay, 80% Arms and some of the other plaintiffs went back to Judge O'Connor and sought an emergency motion for a preliminary injunction. They asked for Judge O'Connor to put back in place his prior preliminary injunction that protected their company and also their customers. Essentially, they argued that the Supreme Court's emergency stay that they just issued only prevents a nationwide vacatur of the roll, but the judge can still step in and keep his prior limited injunction in place and introduce a completely different legal remedy, which is an injunction on review. Judge O'Connor agreed and granted the injunction.
They were and shot by someone and couldn't defend themselves because their guns were taken from them.
Well, Mr. Wilcox, there's no law. Congress didn't pass it. That's a rule from ATF.
Running for President of the United States wanted to strip away our enumerated constitutional rights.
In his order, Judge O'Connor stated that having considered the arguments, evidence, and applicable law, the court holds that it has ancillary jurisdiction to enforce in equity the portions of its summary judgment order and final judgment that remain in effect following the state order of the Supreme Court of the United States. The court also holds that the relevant factors weigh in favor of granting injunctive relief to intervener plaintiffs. The proper scope of relief is that which mirrors the relief previously granted to intervener plaintiffs at the preliminary injunction stage, plus an extended effective period that mirrors the expiration timetable of the state orders by the Supreme Court of the United States on August 8, 2023.
These pistol braces make a normal, law-abiding person suddenly a violent criminal is bizarre.
Now, what happened with Fast and Furious? With these traced guns that they lost, thousands of them.
Firearm equipped with the stabilizing brace was, quote, would not be subject to the National Firearms Act.
So, Judge O'Connor granted an emergency preliminary injunction that puts back in place the prior injunctions that he had issued to the individual companies like Defense Distributed and 80% Arms. He's putting back in place that injunction that protects the companies and their customers. Of course, the ATF could not have that type of injunction sitting, so they decided to file an appeal once again, back up to the Fifth Circuit, arguing that Judge O'Connor is directly defying and trying to circumvent what the Supreme Court just issued in their emergency order. The ATF argues that Judge O'Connor cannot issue this injunction because of that emergency order. Orders were received from the Fifth Circuit that they will be hearing arguments on this issue. The parties are set to have oral arguments in the Fifth Circuit whether or not Judge O'Connor's injunction is barred by what the Supreme Court said in their 5-4 emergency order. In our opinion, the ATF will lose this argument because a vacatur and an injunction are completely different legal remedies, and the Supreme Court's order was specific to a nationwide vacatur remedy. It did not impact something like an injunction that Judge O'Connor just re-granted.
Banning a class of weapons that you don't like the look of, not because of functionality.
Maybe 3%, maybe 5%, but we're looking at what could have prevented 90% of the mass shootings.
Here's a 12-round magazine. This magazine would be banned under this current bill. It doesn't fit.
Why is the ATF trying to say a pistol's no longer a pistol? If you use a pistol brace, it's a short barrel rifle.
Ban weapons, ban them again, do it now, enough, do something.
However, also interesting is the fact that the Fifth Circuit also ordered that the ATF needs to answer two specific questions before this hearing. Those questions are: 1. Does the United States government intend to enforce the ATF's final rule pending appeal with respect to the parties in this case? 2. Does the United States government intend to enforce the ATF's final rule pending appeal with respect to the party's customers? The court states that the government is welcome to file a response of any length to both questions, but the answers should begin with yes or no. What is happening here is that the ATF is being backed into a huge corner. They will have to outright state how they intend to enforce the rule going forward.
Certain bump stock devices, like the one used in Las Vegas, are illegal under current law.
Why is the ATF trying to say a pistol's no longer a pistol? If you use a pistol brace, it's a short barrel rifle.
Partisans at the ATF have really run amok, infringing and trampling on the Second Amendment.
We doubt the ATF will say that they do not intend to enforce this rule, especially since all of their appeals and all these emergency stays and requests are based on the fact that they want to be able to still enforce this rule. So there is a doubt that they will say no, they don't intend to enforce it against the companies and their customers. But telling the Fifth Circuit that they intend to enforce it also further solidifies what the companies and the customers are afraid of, that they need an injunction to protect themselves against these ATF actions. Really, either way, the ATF is in a huge losing situation. So you may be asking, where does this leave us? Well, the Fifth Circuit is holding oral arguments on the frames and receivers case.
The pistol brace also does not help the shooter load the pistol more quickly.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
And on the whole issue of whether or not Judge O'Connor's injunction was proper or not, because of that recent 5-4 emergency order that was issued by the Supreme Court. Also, the ATF is now required to expressly state if they intend to enforce their rule going forward against these companies and their customers. This is going to be a very important battle going forward, a very important argument that takes place. The likelihood is that it's going to be able to be listened to live if you want. Make sure you're staying tuned because this is going to be a very dynamic situation. That's all for this video, folks. Thank you so much for watching, and we will see you in our next video.